Good afternoon. My name is Deborah Jennings. I'm a retired partner from DLA Piper, which is a global partner law firm. I was a partner there for 30 years, and 20 of those years I headed the national environmental practice. Our topic today is the intersection of class action and, in the environmental cases, with environmental regulatory proceedings. So I have a very esteemed panel to my left, two judges and two very high-end plaintiffs' lawyers who bring these kinds of cases. I'll introduce them as each one speaks. Specifically, what we're going to talk about is the applicability and suitability of a class action to major environmental contamination cases. When you have cases like this, there's always a lot of publicity, sometimes national publicity. When that happens, just about inevitably, there is an environmental enforcement proceeding that could be brought by EPA, it could be brought by the state, or it could be brought by plaintiff's counsel on behalf of class members in a citizen suit. We're going to talk about, as I mentioned, the suitability of class action to these kinds of cases, but also the significance of participating in that regulatory proceeding, either as an intervener or as a citizen suit plaintiff, and the strategic advantages and additional leverage when it comes to settlement and so on that can be achieved by being an activist on the environmental regulatory side. Now, the kinds of cases that we're talking about typically involve an industrial facility that has caused significant contamination of the community. It could be by contaminating the groundwater that they're using for drinking water. It could be by giving off emissions that the entire community has had to breathe. And also, in the course of doing this, it causes significant stigma and environmental property damage. So these are big cases, very often in the $100 million plus category. One such case was a case called Mount Dare, just settled by these two guys to my left. You'll probably hear more about it. But that involved a chicken processing facility that was using animal waste in a land application process in a very sandy soil near the ocean. And it had the effect of dropping right to the groundwater, contaminating it, and we had a whole community drinking the water. In addition to that, these animal waste cases give off noxious gases, hydrogen sulfide, and the entire community smelled like rotten eggs and was breathing these substances. So they brought this case. You'll hear more about it, and you'll see that it's very suited to the class action vehicle. So I'd like to begin by calling on Phil Federico. He is the founding and a senior partner at the firm of Shakur, Federico & Staten. He manages the mass tort and environmental law section. He's brought many cases that have historic significance, that are cutting edge, and most recently, he's focusing on environmental contamination cases. So the first question is, how do you find a case like this, Phil?
You have to be lucky. There are basically two fundamental ways that we find these environmental class action cases. Typically, we have a group within our group that really, it's their job to look on a daily basis on the internet. As Deborah was saying, pollution cases tend to get a lot of traction when it comes to the media. So, when these cases do happen, when they come about, it's pretty easy for us to find them because they're on the news or they're being written about. So that's really one of the ways that we initially find cases. Another thing that we see quite often is the EPA and various state agencies. Each state has their own version of the EPA. They are trying to police corporate America when it comes to pollution. And so a lot of the work that they are doing, a lot of the citations they are issuing, permit violations they are issuing, lawsuits they are filing, will bring various cases to light that then become cases that a class action might be suitable. So that's another way we find that. We find a fair number of cases on our own, but interestingly enough, a fair number of cases find us. When you work in a particular space for a long enough period of time, and a lawyer or a law firm stumbles upon a case that really isn't in their wheelhouse. Either they don't have the bandwidth to do it, they don't have the finances to do it, they will then seek to find a law firm that does. One of the things that's going on in the environmental class action world is because the defendants typically are so big. The case Chase and I are handling now, the New Indy case. It's a paper mill in South Carolina, and it's owned by Robert Kraft. And so it's a company that really has an unlimited amount of resources and an unlimited amount of attorneys. And knowing that this case, the size of the class is going to be in the hundreds of thousands of people, we looked to try to partner with somebody else, which is very common in mass torts and class action. If you grew up as a plaintiff's lawyer like I did, doing one-off cases, what you'll typically see is 3 or 4 defense lawyers sitting across the table from you, and you're there by yourself. Under these circumstances, we try to level the playing field. So we actually get called upon to come in and participate in cases that somebody else found. So there are a number of opportunities out there to work on these cases, but case selection is essential to success.
And what criteria do you look for?
Well, I was taught by my very first mentor that the most important thing if you're a plaintiff's lawyer is damages. You can have the greatest liability case in the world, and unlike the group that was talking before us, where you can have like small damages per individual, in the class action environmental space, we know we're going to spend at least $1 million a year in expenses on the case. And we know the case is going to go 3, 4, 5 years. And so we have to look for a large enough area that's been impacted, where demographically there are enough people that have been impacted, so that when we look at the personal injury aspect, because we look for personal injuries, we look at the property damage, and maybe the most important criteria we look at is something called a remediation. What is it going to cost the defendant to actually stop polluting, immediately, and then correct the problem permanently? And very often that is really the biggest bucket of all the buckets of damages. That's the biggest bucket. So first we look at damages. You certainly have to have a strong case of liability, and it's usually pretty strong because they've usually already been cited for multiple violations, and then the size of the class is very important as well.
Now, once you find the cases, of course, you have to put together a team. So let me call on Chase. Chase Brockstad is a founding partner of Baird, Mandelis, and Brockstad. He manages the mass tort class action practice. He's been the lead lawyer in a number of cases, and among them are many that are the largest cases ever settled in the state of Delaware. So let me call on Chase to talk about how you put together the team.
Thank you, Deborah. The first way, when I'm looking at a team, is I want to make sure that I've got everybody that is surrounding me a hell of a lot smarter than me. So that's sort of the cornerstone of how we build these things. But obviously, we're looking for lawyers on the legal team side. There's sort of 2 parts. One is the legal team, the other part is the expert team. On the legal team side of it, we're looking for lawyers that have class action experience, lawyers that have environmental experience, who have prosecuted cases like this. Oftentimes, we utilize consultants as well, who maybe have retired from the practice of environmental law or otherwise, experts in a particular field. So we want to make sure that we've got the right lawyers, the right sort of institutional knowledge and expertise. We want to make sure that in terms of if we're going into a jurisdiction like we are in South Carolina or in other places, we have the right local counsel. That's somebody obviously with familiarity with the court, ideally with a particular judge, as well as some political connections. As we're going to talk about a little bit, these cases tend to get quite political because you either have the state regulator involved or the EPA. And really also on the legal side of it, we want to make sure that whoever we bring in, whatever lawyers or firms we bring in, they've got the bandwidth to do the work. I mean, these are pretty intensive cases, lots of document review, reviewing FOIA documents and the like. And so you need bodies for these types of things. So that's sort of on the legal team side. On the expert side of it, basically we're looking at, liability, we're looking at causation and damages. So, if it's an air case or a groundwater case, we're looking for hydrogeologists. We're looking for folks that have the expertise who can fingerprint what it is that is, the source of the pollution and sort of how it's affecting the community. And on the damages side of it, there's really sort of three buckets that Phil touched on. If you've got a case with personal injury and health effects, then you've got a personal injury component to it. There's usually a property damage component. The pollution has caused a diminution in the property values of the homes and the residents in the community. And then there's the remediation bucket. And the remediation bucket of damages really is sort of the most important for the folks, because they want this, the folks that are impacted by this, the victims, they want it to stop. So they want it to stop right away, and then they want it to stop permanently. And part of that is remediation, and then ultimately cleaning up the area, improving the plant, doing what's necessary to make sure that the pollution ends forever. So you've got sort of the liability side of it and making sure that you got the right expert team there. You've got the damages side of it to make sure that you've got the right folks who are able to provide the opinions that you need. And then you've got to have the causation piece. So we've got to be able to prove that the pollution, whether it be air, groundwater, both, whatever, has caused the health effects, has caused the property damage, and it is required to be remediated.
Could you characterize the numbers of experts that you need approximately, typically, and also the cost?
Too many?
Too many, yeah.
Too much?
I mean,
Too many and too much.
just sort of going back. Yeah. Just going back, I mean, I know that when we filed the Mount Airy complaint that you talked about, I think that we filed that complaint attaching a dozen expert reports. We did that strategically in that case a little bit because pre-suit, we were met with a lot of publicity and opposition that there was nothing to see here. And there was really sort of an outreach by the defendant in that case to curry favor with the public and get the public against this lawsuit. So in that particular case, we felt like we needed to legitimize the allegations up front. So in that particular case, we had, I think, a dozen experts when we filed that complaint. But it's not uncommon for us to have 10 to 15 experts in a case like this. And like Phil said, it seems like we always sort of end up right around that $1 million a year in expenses, the bulk of which are on the expert team.
Okay, as you mentioned, there's a lot of publicity in all of these cases, and there's an inevitable parallel proceeding for enforcement. And I'm involved as a consultant, and we've seen cases where EPA brings a case, or where the state version of EPA brings a case, or where there is no case, but the environmental statutes all provide a citizen suit opportunity. So a case can be brought by members of the class. I want to call on Phil to talk about how this happens and some of the strategic advantages.
Yeah, it's very interesting what typically happens, and you really have to pay attention. Because if it's the EPA, they will sue whoever your defendant is, but it's a friendly lawsuit. And they have been talking to this defendant usually for weeks or months, and they will try to draft what's called a consent decree, which is really a settlement agreement. And typically, what the either state agency or EPA is demanding of the defendant is about 10 to 20% of the real remediation that needs to be done to stop the problem and stop it permanently. In one of our prior cases, the local state agency had met with the defendant, and they had filed this consent decree, both in state and federal court. And the plan was to get it signed and then get our remediation out of our class action case. We certainly were aware of what was happening. We brought it to the attention of the court, and refreshingly, the judge was furious. He said, "This is dirty pool. This is not fair." Okay, and so what happened was we filed something called a motion to intervene, a motion for intervention in that case, because we're not a party, right? We represent all the citizens in the area. The state theoretically is supposed to represent them, but or the EPA, they typically really are not doing a very good job because they are being influenced politically by the defendant and all the politicians who are supported by the defendant, frankly. So we come in, we file a motion to intervene. We have to show, that the state's not doing a good job, the EPA is not doing a good job. Under certain circumstances, we have an automatic right to intervene. And judges are usually pretty sharp and understand, frankly, that the environmental sort of space that exists now and showing our expert reports versus what they're trying to do to fix the problem, there's usually such a gross disparity that we're typically permitted to intervene. And sometimes we have a right to intervene and they really can't keep us out. The last case we were permitted to intervene with full rights of a party. And we want a seat at the table if they're going to try and settle remediation. Because if they settle remediation on the cheap here, they're going to come into our class action and say, that problem's already been taken care of. All you have now is just your property damage and just your personal injury, which really undercuts our class action case because the most objective damages we have are the remediation component of the case. So typically we're allowed to intervene, and really it's our job, and it's pretty interesting, to really play defense, which doesn't come naturally to us. I mean, we are slow rolling the federal case, okay, the enforcement case, while we're pushing our class action case forward. Typically, the defendant finds it very frustrating. Typically, it serves as an enormous amount of leverage for us. And typically, we wind up getting the remediation part of the case settled before they can ever resolve the actual enforcement case itself. And that's the technique that we are using, and we've used it very successfully. And that the other thing it does is it brings the defendant to the settlement table earlier than they would otherwise come to the table in a class action.
Just to add a little bit to that, when Phil said you gotta watch what's going on and stay on your toes, in the case that Phil referenced where we were able to intervene with full rights, in that case, the state agency filed a complaint, and simultaneously they filed they lodged the consent decree, which was the settlement agreement, right away, like instantaneous, one after the other. And they did it both in state court and federal court, ironically asking the state court judge to bless the consent decree. And the reason why that's what they did is because we don't have an automatic right to intervene under some states. In this particular state, we did not. So knowing that we had the right to intervene in federal court, where part of the enforcement case was pending, but not in state court, they tried to use the state court as the vehicle to get the consent decree signed, blessed by the judge, rubber stamped really by the judge. So you have to stay on top of that. And in a case that we're in right now, we met with the agency and had a meeting with our experts and their legal team. Thought we were, making some progress with them, and a couple of days later they turned around and they did the same thing. They lodged a consent decree without sort of any notice to us or anything like that. So we obviously had to move pretty quickly. So you gotta watch out for that and always know what the regulator is doing. And even though your interests should be aligned, they're there to protect the same people that you represent. Many times that's not the case.
Yeah, and it's not unusual for there to be a really meritorious, very solid environmental class action case out there that you're working on, where the EPA or the local state agency has not filed an enforcement case. What do you do under those circumstances? Well, you do have the right to bring a citizen suit. And again, the leverage that you can get with a citizen suit is often very helpful in trying to get the remediation portion of the case resolved, which is really, we think, probably the most important part of the case, because we're talking about fixing the problem. People look at plaintiffs' lawyers and say, they're just out here for the personal injury, they're out here to get the money. No, our number one priority is to fix the problem, to stop the pollution immediately, and make sure we never see it again in this particular community.
You should be aware that although in federal court there is a process to comment In almost every state, there is no process. There's no ethical obligation by the state agency to give notice to anyone. So it's very typical to run into court and essentially get a consent decree signed ex parte. So you really have to be on top of things. Now, Phil, can you comment on what the impact is on your ability to sell class action?
Yeah, you have to remember that the corporate defendant that we are against in really every case, they're in the business of making their product, making it as cheaply as they can, and turning a profit. Now, the reason that they're usually in the position they're in is because they didn't spend money along the way to maintain environmental compliance and environmental responsibility. So they are violating typically their permits. They are causing objectively provable damage to the groundwater and or the air. But they know they have to fix the problem, because if they don't fix the problem, they're essentially going to go out of business. And so really this enforcement case, the other thing it does is from a public relations standpoint, from a marketing standpoint, really from a media standpoint, puts a lot of pressure on corporate defendants who typically are employing people in the same community. Many of our clients actually work for these plants. And so it puts them in a situation where they typically realize they're going to be paying anyway sooner or later. Maybe it's time to fix the problem. And having sort of two lawsuits going on at once, eventually the weight of both lawsuits, the enforcement action and the class action, becomes more than it's really worth. And they finally, typically, throw up their hands and say, we have to make this go away. But it takes quite a while to climatize, a big corporation who's used to getting everything they want to write a big check.
I'd now like to call on the Honorable Benson Legg. He is a retired judge from the United States District Court for the District of Maryland, where he served as the chief judge. And he now does arbitration and mediation for JAMS. You may be familiar with it. It's the largest alternative dispute resolution in the country. Judge Legg, would you give us the judicial perspective?
Good, thank you. When I was a newly minted federal judge, I got a call from the former governor of Maryland, Norman Mandel, who was practicing law. And my secretary said, "You got a call from Governor Mandel." And Governor Mandel wanted to talk to me about a case that he had pending. And he was absolutely shocked and flabbergasted when I wouldn't talk to him ex parte. So always remember, when you are handling an environmental case like this, or any case involving a state regulatory body, that the politicians can and will call up the regulator to a jawbone them about what they think should happen in the case. There are two types of collective actions in federal court. There's the mass action and then the class action. A mass action, mass actions today make up about 50% of the federal caseload. And of that 50%, half are pharmaceutical cases. Pardon?
Bring that a little closer.
Oh, good. Are pharmaceutical cases. Mass actions have no common issue because they're by definition, and particularly in the pharmaceutical case, personal injury cases. The class action, which we're talking about today, is, well, let me go back and just give you another word on mass actions. They're generally handled by a multi-district litigation where these thousands of cases are aggregated before a single judge, federal judge, who handles the common issues, primarily discovery, but the judge can also handle the Daubert issues, and if he agrees that the case should be dismissed, just dismiss all of them on Daubert grounds. After the judge has handled all of the collective common issues, the state cases are remanded to state court for trial, And the federal cases are remanded to their federal court of jurisdiction for trial. The problem with from the plaintiff standpoint with respect to and also the defense standpoint with respect to the MDL is these mass actions can't buy peace. And the advantage of a class action is that either the settlement or the verdict binds all members who have not opted out. Buys peace, that's the holy grail. That's the primary benefit that plaintiff's counsel can extend to the defendant. And it's what the defendant wants. Environmental contamination suits are suitable for class action treatment. The harm, namely the pollution, is perfectly suitable for class action because what the plaintiff's counsel and the experts are essentially doing in the Mount Air case, for example, is quantifying the pollution that is in the wells of all of the people who surround the Mount Air plant, measuring the pollution and establishing that yes, it's not just groundwater in the well, but it's also significant fecal matter and other waste products of the plant. Moving down the list, you have property damage. Property damage can also be handled, if done skillfully, on a class action basis. If we move into personal injury, health monitoring can be handled on a class basis because basically young, old, infirm or not, are then entitled to monitoring by a health professional for a certain number of years in the future. It's the personal injury aspect of the environmental case that is the trickiest for plaintiff's counsel and also for defense counsel who want to settle the case and get the advantage of buying peace. So if I have lung cancer, or if I have some other form of illness, that really can't be handled on a class action basis unless we have Harmonie, who is handling the case. So what you do then is you have an allocation of money to handle the personal injuries, and then the personal injuries are going to be compensated by a process that is worked out beforehand and then implemented by Judge Raker. So what you've then done is by the settlement process, you have essentially created a common issue because, Judge, we've created this mechanism for handling all of these personal injuries, and it's all going to be done on a, collective basis. And that works very well.
It does, and since the title of this program, somewhere I saw economics and ethics. So let me say something about ethics, just so I can cover that. The reason the plaintiff's lawyers are not involved in the case after it settles is we represent the whole class. And everybody's competing for the same dollar, or a slice of the same dollar. So when the case settles, the court is presented with what is called an allocation plan. And it permits us to step out or step back. And all the class members then are put in the hands of an allocator, like Judge Raker, who will then go about very systematically trying to determine as objectively as possible what people are entitled to. And so that's really how we solve that potential ethical problem, because the allocator really has no skin in the game, doesn't represent anybody, and is just looking to make a fair distribution. So when we also talk about the economics, obviously the goal is for everybody to get treated fairly. And a good allocator usually has no problem doing that. Right, Judge?
We'll look for Judge Raker in a moment, but let me ask Judge Legg. I heard you mention that it's important to sort out counsel as a judge. What do you mean by that?
Yes, let's assume you're a hardworking federal district judge, And in today's world, with the explosion of crime in our big cities, really it's mostly the medium-sized cities, there is tremendous pressure to take cases and move them into federal court, where we have federal juries, the conviction rates of 99% for the cases that go to trial, and only about 5% of the cases do go to trial. So in state court, the conviction rate would be 30%, but in federal court, it's about almost 100%. So the judge has all of these criminal cases, and then he also has all of the routine docket of civil cases, Title VII cases, Americans with Disabilities Act, and the like. And then all of a sudden, in marches, about 100 lawyers for the MDL or the class action. And what the judge is looking for is a pleasant, reasonable, well-prepared, agreeable attorney or two that the judge will then call on in every conceivable moment. And so what the judge does is he then sorts out counsel by, they're the misleaders. They're there just to make things more complicated and to mislead you if they can, so never call on them again. Then there are the empty suits, and there are plenty of them. So if you're dealing with a big firm, you've got the big partner over there. What you're really looking for is not the big partner. You're looking for the associate who's really doing all the work of the junior partner. Mr. Big, we'll hear from you later, but let me talk to your associate right here. And those are the people that you're really going to be guided by. Also, try to help the judge out. Before you march into court with your phalanx of lawyers, submit an agenda. Judge, this is what we suggest that we talk about at this hearing. File the agenda with the court beforehand. State what you all have agreed to and identify the areas that are in dispute. And that will help transform this, sort of morass into something that the judge can get done. Because remember, you're living with this case on a day-by-day basis. Tomorrow and the day after the hearing, you're still going to be living with that case. You're going to know it from soup to nuts, but the judge has sort of already forgotten about it because he's moved on. So try to get, for every hearing, an agenda of things that are actually going to be decided and ruled on in the near future.
Thank you. Well, before we go on to the claims adjudication, there is the all-important topic of fees. So I want to call on Chase to talk about fees in these cases and also the significance in the fee matrix of having the parallel enforcement proceeding.
Thank you. So there's two, theoretically there's two actions that are happening. One is the enforcement case. It's a case that's been brought by the state agency or the EPA or both. If they haven't brought an action there, you can file a civil suit and you can start your own action. In that particular case, depending on the result, there is the opportunity to apply for fees. And really what you're seeking in that enforcement case, if you can't do it in your class action, is the remediation part of it. So Phil was talking about, a lot of times that these lodged consent decrees, these settlement agreements are one of our phrases, it's a Band-Aid on a gunshot wound, right? They're trying to get out as cheaply as they can. The corporate defendant is trying to just make the state or the EPA acquiesce to the bare minimum. So there is the opportunity for fees depending on how the enforcement case goes, if you're able to intervene, etc. Separate and apart from that is the class action case, the tort case. And so there you're seeking damages for the recovery of personal injury, property damage, and potentially remediation depending on what's happening in the enforcement side of the case. And there you can apply for a fee. It gets approved by the court, and then that's sort of when the lawyers and their clients have to go into two separate camps, because now the fee that you're applying for is theoretically taking money away from the class distribution. So that's sort of at that intersection of money and ethics, which is the name of this seminar.
And so there's another interesting aspect. So there are really two fee pots, if you will. There's the remediation fee pot in the enforcement action. And what we would prefer to do there, you can't take fee money out of the remediation money, because you're only gonna be able to do 80% or 75% of the work that needs to be done to clean up the problem, right? So we negotiate with the corporate defendant and say, look, you need to pay a legal fee for the remediation you're gonna do. Of course, they look at us like we're crazy. What do you mean? Why do I have to pay you, the plaintiff's lawyer, for the work we have to do to clean up the problem? Well, because if I wasn't here, you wouldn't be doing it. That's number one. And number two, you can't take it out of the remediation because you really have to fund the remediation that needs to be done. And so we ask them to pay the fee, and they really do pay the fee. And the reason that it's I think somewhat advantageous to the client is it really doesn't have any negative impact whatsoever on the client. But you say, how do you figure out the fee, right? And so what we do is, remember that sweetheart deal I was telling you about? The enforcement action in the beginning? The EPA is trying to come to a settlement with the defendant. Well, as I said before, it's typically about 10 or 20% of what happens. In our last case, they were ready to sign a consent decree for $22 million worth of remediation for this chicken processing plant in Delaware. When we got finished intervening in the case and negotiating a remediation settlement, they were paying $140 million to do the remediation. So 140 minus 22, whatever the percentage is really what we use to try and negotiate the fee. So that's how that portion works. The other portion is pretty simple for anybody that's done plaintiff's work. It's a contingency fee kind of fee, but we really need to be mindful of the court likes to justify your percentage. It's not like a one-off slip and fall auto tort where you can charge a third or 40%. Typically the courts are a lot more conservative in terms of the percentage that they will give you. And the better job you can do of justifying your fee, the more likely it is it's going to get approved at the rate you ask for. And then we do recommend that whatever your normal rate is, you should tell the court that. You should ask for something less than that, and hopefully the court will go ahead and approve it.
Okay, now I'm going to call on Judge Raker. Judge Raker served for 14 years on Maryland Court of Appeals, which is the highest court in Maryland. Prior to that, she sat on a trial court in Montgomery County, Maryland. And by the way, she and I were prosecutors together as baby lawyers 100 years ago. She is a very highly regarded and respected judge, and now she spends her time doing claims adjudication, arbitration, and mediation. She's going to talk about what you do once you have the pot of money.
Thank you, Deborah. Well, I'm the person who, after the battle, kind of swoops down and tries to minister to the survivors. Some of them are happy, a lot of them are not very happy campers. And so my role, sometimes it's called claims adjudicator, sometimes I'm designated as a special master, but my mentor, Guru Ken Feinberg, says in two of his books, which by the way I recommend, although I don't get any royalties, who gets what and what's a life worth. And so that's basically my job. And while it may look simple in the talking, there's a lot of layers to that onion. And each time I do it, I see something new and learn something new and see new questions that come up. And so as Judge Legg talked about, particularly in an environmental case, the issue of compensation and crafting a fair award is very difficult and complicated, and even more challenging, I think, in environmental than if you have even a sexual abuse case, for example, and we see more than we should in this country on sexual abuse cases by either coaches or teachers or doctors, gynecologists, male doctors. And many of those injuries are common but psychological nature. In an environmental case, we have a plethora of damages. We've got, as Judge Legg said, the property damages, the personal injury, and I don't know how you would categorize loss of enjoyment of your property, whether you call it personal injury or property damage, but there's the loss of enjoyment. And then also included in the personal injury, maybe yes, maybe no, depending on how the settlement process is crafted, also the psychological impact on the anxiety on the claimants. So for you practitioners, if I were to pick my 2 top points to tell you to take away from what I have to say would be, 1, when you are crafting your settlement agreement, remember that when you have an allocation process in that document, you may be tying the hands, and you generally are tying the hands of the claims adjudicator special master, which at the end of the day is charged with exercise of discretion. And I suggest that when you can, that you talk with a claims adjudicator and claims administrators also, because I work closely with the claims administrator to run your allocation process by somebody who's hands-on and doing it. Because there are many different models and many different choices. For example, you can have tiers set up where you'd have the most severe tier would be tier 4, severe, then you have moderate, mild, and then the 4th tier, which would be you're simply a class member, but you don't have any perceptible injuries or damages, or very, very minor damages. So that would be number 1, my number 1 point. Bring the people who, at the end of the day, are going to be dealing with the clients and the claimants who are often very unhappy because they haven't gotten their money yesterday, but they're reading in the newspaper that the lawyers have gotten paid and they haven't. So they're unhappy. So bring us in early. And secondly, think about client expectations, because while the process is going on, you're their lawyer. And then when it's settled, like Phil said, that class counsel can't be directly involved vis-a-vis individual claimants and individual awards, but a lot of times the clients really don't understand that. They don't understand why their lawyers aren't there. Many times they don't understand that this is not an adversarial process. And even though they're getting letters from the claims adjudicator and claims administrator about what's going to happen, and many times there's a website, they really don't understand what is said in the letters. They don't go to the website, and so don't overpromise. Because again, I think maybe it was Chase who said, you're working on these cases for 3 to 5 years. The clients, while they want remediation, once that's in place, they want their money. And there's a lot of steps that a claims adjudicator has to go through before they can get their money. Eligibility, which is very time consuming, and tricky. There's a lot of duplicate claims that are filed that have to be weeded out. There's some fraudulent claims. There are claims administrators know and they call frequent flyers. People who are filing on every class action where they have just absolutely no basis. We try our best to ferret those out. I don't know how many we miss. I hope not very many, but you can. So it takes time. That's my point. So don't overpromise to your clients.
Judge Ricker, are there times when you need expert assistance?
Yeah, absolutely. And so, for example, in the property diminution claims, yes, if the plaintiff's expert report is helpful, but so is the defense expert report, if it's available, is helpful. And then there are independent experts that I might consult and hire, because we're dealing with very technical things, and just like I think Judge Lake saw sitting on the bench for all those years, we're kind of generalists. You know, we don't have the expertise in like you all do, but you need to be educated. So absolutely.
Chase.
Yeah, I was just going to add, during the pendency of the case for that 3 to 5 years, we are constantly writing client update letters every 45 days, max sort of 60 days, letting the clients, letting the class know what's going on with the litigation, where things are, what if there's a schedule in place, what the schedule looks like, if there are certain milestones that are coming up, if there's a mediation coming up, those types of things. But once the case settles, and I think we try to over communicate during the case, but I think it becomes even more important to over communicate after settlement, because they've heard from the same group of people, they've heard the same voice for 3, 4, 5 years. We're now going away, and they're going to be hearing from somebody else. So making that transition as smooth as possible and as easy as possible, so that like Judge Raker said, we don't have upset class members, upset client, that type of thing. That's really critical in that phase of the case.
I think we have about 10 minutes if there are any questions and answers, and we'll give you answers. Anybody have questions? Yes.
All right, so I have a couple of questions. In the class action space on an antitrust, before the allocation process, so at the very beginning of the case, there could be a lot of litigation over whether there are conflicts within the class and whether separate lawyers need to represent different pieces of the litigation. So for example, in your world, have the courts basically ruled that the property and personal damage people can be represented by one set of lawyers, or do they have very distinct interests because the legal claims are very different? One might be a lot stronger than the other, or is that left for application?
Yeah, typically, if you're a class member, typically if you have property damage, in order to qualify for property damage, you have to live on the affected property, typically. And if you live on the affected property, you're going to have a personal injury claim. Now, it may just be a monitoring claim because you haven't manifested any illness or disease. But typically, the vast majority of the class members wind up in the different buckets. So there's really not an obvious conflict where you would need different counsel to represent them. Pragmatically, really what we do is we try to put together the plaintiff's steering committee before we go to the court, before we file the lawsuit. The biggest challenge for us is rarely the defense and the defense lawyers, who are always very good and typically very easy to deal with. But you put a half a dozen plaintiff's lawyers, all of whom want to run the show, in a conference room, who all have their own idea about how the case should go, right? And it can be a little challenging. So we try to, and the reason we try to do this is so when we show up in front of Judge Legg or we show up in front of Judge Raker, they don't do class actions every day. As they were saying, they do all kinds of cases. If we can come in and make it simple, here is the steering committee, and everybody, all the lawyers say, yes, this is who we want on the steering committee. Here's lead counsel, and everybody's in agreement. You know, the judge is like, great, you know, you're the person I'm gonna talk to, you're the person I'm gonna deal with, and the agenda part, I've gotta go back to that. Anytime, judges welcome when you can make their lives easier, because frankly, their lives are not easy. You know, litigation, the way it's exploded, you know, over the course of the past decade or so, they are really overtaxed. So anytime you can make their lives easier, and an agenda is the perfect way to do it. And it's not just you getting together with your co-counsel and putting together the agenda. The most important part of the agenda is once you do that, getting together with defense counsel so that when you're in front of the judge, guess what? You're not fighting. And if you are, if you can't reach an agreement and you're agreeing to disagree on a point or two, it's so much easier than just really trying to build the house from the bottom up when the conference with the court starts. You can really just walk in with a house that's almost built, and it makes life a lot easier for everybody.
Other questions? Did you say you had more than one?
Well, I was gonna ask a question about the fracking area and the politics that you raised. So when you decide whether or not you're gonna bring a case, do you look at the political situation, for example, there may be a jurisdiction in Texas, and you say to yourself, I'm never gonna be able to battle them because of the way their local regulators view things? Does it make you shy away? How much influence does the EPA really have under that circumstance to be a kind of, at least initially, even if it's only 20% of the remediation? You know, so, and also I suspect that causation is not as clearly established yet. So what are you doing in the fracking area and how the politics are playing in?
Well, we haven't done a fracking case, but that's a great type of case to sort of illustrate sort of the politics in environmental law. I mean, I can tell you things were not easy for us before the Biden administration, under the Trump administration. And in the case we were working on at that point in time, we actually, through FOIA requests, got a number of emails and memos that were exchanged between a particular governor and a particular owner of this chicken processing plant. And it was just amazing how blatant this conversation was, right? And the reality is you can have that email all you want, but if that is the political sort of environment you're in, and if the juries of that jurisdiction, you know, are in keeping with that kind of sort of political view, then you may have to revisit what you're doing. So it's not just, it's looking at the venue, looking at the makeup of the juries, but also talking to the politicians. I mean, it is not uncommon for us. Matter of fact, it's typical for us while we're vetting cases to reach out to a US senator or reach out to a congressman or state senator or governor and meet with them and talk about the situation. If you know you're going to get enormous resistance, it's a factor. It may not be a game changer. It may not, you know, have you reject the case, but you'd really be remiss if you don't explore that when you're vetting the case. And frankly, when the wind is blowing in your favor, no pun intended, it can be very helpful. I mean, very helpful. Doesn't happen often, okay? But if you see that train going by, you're going to want to jump on it.
A big part of the political process too is educating the officials, whether it's the EPA or the state. You know, a lot of times they don't have the budgets, they don't have the manpower, they don't have the resources to employ a dozen or 15 experts like the plaintiffs can. So, you know, we always offer up our experts to the state regulators to say, hey, listen, let's have a conversation here so we can share our thoughts and our opinions with your engineers and your folks. It's also really important to educate the politicians. At the end of the day, the people who are harmed by this are the same voters that are putting these politicians in office, right? So much like the EPA and the state agency, you would think our interests are aligned, despite the fact that they almost always oppose our intervention into these cases. But we're certainly aligned with the politicians. They want their constituency to be happy. They want them to be healthy. If there's a problem, they want to at least appear as though they are being proactive and doing something about it. So establishing a dialogue with them early on in the case, continuing to educate them, provide them with information, provide them with filings that we make, or expert opinions, or the summaries of expert opinions, so that when they send out their letters to their constituency about a particular issue, they can be informed. And we've been fortunate enough where we've established some great relationships that way. And again, it's not, hey, we need you to do this. I mean, there may be a point in time where we make that ask, but really it's just about keeping them in the loop, and we find that they're very appreciative.
Just one, read a really interesting book recently called The Gulf, which is about the Gulf of Mexico, which is very fragile environment, cheap highjack of the petroleum industry, and also a lot of manufacturing. And according to what I've read, and sort of anecdotally what I've talked to people about, you're gonna have the biggest problem in the one company town, where you have a town and just about everybody works for that company, that's their livelihood. That's the real uphill battle, because you do not have a sort of an independent group of citizens who's really concerned about what's happening in the water and in the air.
Judge, that's an excellent point. And one of the things that Phil and I have done, and I think the first time that we did this was in 2009. But when you have a corporate defendant like that, they're a big revenue generator for the town, big employer for the town, huge tax base, all of those things. It becomes very important to make sure that you're not trying to put this company out of business. You're not trying to shut down the plant. You're not trying to take away these jobs. What you're trying to do is you're hoping to hold them accountable. Hopefully they will become a good corporate neighbor and a corporate citizen. And ultimately, you want the company and the business to survive and ultimately thrive. They just need to do so in an environmentally compliant way. So it's really, that messaging throughout the case, but certainly in the beginning, is very important.
We probably have time for one question. Are there any? Any closing comments from the panel? We have 1 minute.
Take care of the air, take care of the water.
Right.
Thank you very much.
Thank you.
Thank you.